have started off our first unit of banking, right? We have discussed the general relationship between a banker and a customer. We discussed 6 different: debtor and creditor, agent, principal, bailer and bailee, and so on, right? Agent and client. Now, here today we're going to begin the second part of the relationship, that is the special relationship between the banker and customer. As I told, it's divided or categorized into 2 groups. One is the rights of the banker, and the second one is the obligations of the banker. Both are equally important for the bank. Okay, so today we'll be discussing the rights, that is the rights of the banker. So, under the rights, we have a right to lien, right to set off, right to appropriate payment, and right to charge interest, commission, incidental charges, and commitment charges. These are the 4 different rights. Under obligations, we have to maintain secrecy, to provide proper accounts, to honor the checks, to receive checks and other instruments for collection, to give reasonable notice before closing the customer's account. So these are your rights and obligations under the special relationship. Starting with the rights of the banker. The first right of the banker is the right to lien. I want you to remember, what does lien mean? L-I-E-N. Lien means legal right. Okay. So a lien is the right of the creditor in possession of goods, securities, or any other assets belonging to the debtor to retain them until the debt is repaid. Okay, until the debt is repaid. So if Mr. X has taken a loan from the bank, okay, let's say it is from Canara Bank, and he has kept a mortgage as document papers or jewelry, anything, right? That means the banker has a legal right over the jewelry of Mr. X or on the documents of Mr. X. Is that clear? It can be anything. It can be goods. If Mr. X is a businessman, okay, and the bank may have, the legal right over the goods of Mr. X in his godown, right? If Mr. X says, I'll keep the mortgage, my goods in godown, okay, I keep my goods as a mortgage and then take a loan. So the goods will become, the goods will have the legal right of the banker or any kind of securities held by Mr. X, right? It can be bonds, share certificates, American depository receipts, or anything, right? In the name of Mr. X, any kind of securities, bank will have a legal right upon it. Until when can they have the legal right? Until Mr. X completely repays the loan amount. That includes principal amount and the interest amount. Clear? That's the meaning of right to lien. Now, there are 2 types of lien, broadly speaking. There is a particular lien and there's a general lien. Particular lien is otherwise called as ordinary lien. A particular lien gives right to the creditor to retain the possession of only those goods in respect of which the dues have arisen. Okay. Now let's say Mr. X has a big business. Okay, he has so many product lines and so many businesses running under his name. But then only product A, okay, only product A's goods he has kept as mortgage and he has taken a loan. That means the bank has a legal right, that is lien, particular lien upon only product A's goods. But then Mr. X has other things also, right? He has a house property, he has a land, he has product B, C, D, etc. All the other things does the bank have right upon? No. The bank has right upon only on those goods upon which the due has arisen. That means upon which Mr. X has taken loan. Got it? That's called as ordinary or particular lien. Point B is general lien. General lien gives the right to retain the possession of any goods in the legal possession of the creditor until the whole of the debt due from the debtor is paid. That means if Mr. X has 5 different product lines running, he also has securities, he has document papers, or he has some deposits in a bank account. All this belongs to whom? Mr. X. Legally, it belongs to Mr. X. But Mr. X is taken a loan from the bank and has not repaid it. Then bank can exercise a general lien. Okay, a general lien. That is when not only on good A the bank has the right over, but then everything that belongs to Mr. X. It can be documents of his business, right? It can be any stocks that he owns, or any bonds, or any commodities, or even mutual funds that it might be in his name, or even any kind of fixed deposit, recurring deposit, any post office savings account, etc. All these belongs to Mr. X, and therefore it can be held in possession by the banker until when? Until when the Mr. X repays the entire loan amount. That's when the last line says whole of debt due from the debtor is paid. Is that clear to all of you? Particular lien is only upon one particular asset. General lien is legally whatever the person owns, it will be under the possession of the banker. Okay, only until he repays. Once he repays, the bank will have no right upon the assets or securities or documents of the the person who has taken the loan. Let's see some of the conditions for exercising general lien. Now, if a banker has to exercise general lien, what is the condition? These goods and securities must be legally standing in the name of the borrower. It's a very important point to note over here, because if Mr. X has taken the loan, okay, and Mr. X has certain property, Mr. X must be a legally the owner of those assets. It can be a godown, a house, a bike, or a gold, documents, anything. It must be in the legal standing name of the borrower. So in our example, it is Mr. X. If that godown or business does not belong to Mr. X, it belongs to Mr. Y, then the banker cannot exercise general lien. Is that clear? When can the banker exercise general lien? Only when the borrower has his legally name upon his goods or securities, documents, etc. Second, the right can be exercised of checks, bills and shares and certificates. Now that also is applicable, as I just told previously. In case Mr. X has any share certificates, debentures, bonds, or any checks in his name, wholly in his name, then the banker can exercise his right to lien on such securities. The banker can only exercise the lien when the loan is due. I just told you, right? As long as the loan is not repaid, the banker can take possession of all these securities, okay, or the assets. If the loan is repaid, the payment is completed, then the bank cannot exercise any kind of lien. Okay, only when it is due, the bank can exercise the right to lien, especially right to general lien. Otherwise, it is not exercisable. Next, bankers has right to lien on personal assets of partners against the loan given to partnership firm. I'm sure all of you are well versed with the partnership firm and joint stock firm. What are the features, right, or characteristics? We know that partnership firm and partners are the same. Agreed? But joint stock company and its members are the same? No. They have separate entity. Company has a separate legal entity and the members have a separate entity. They are not one and the same. If one member in the joint stock company dies, that doesn't mean joint stock company will close down. Yes or no, guys? But then for partnership firm, if the partners in the partnership firm die, automatically the firm also dissolves. Hope all of you have studied this concept in your PUC, correct? Characteristics or features of partnership firm and joint stock company. I want you to apply that thought over here, where it says the banker can exercise this lien, okay, on personal assets. That means if a partnership firm has taken a loan from a bank, okay, and they're not able to repay it, okay, the amount is still due. What happens then? Not only the partnership firm in the official capacity, okay, the business, the goods go down, etc., but then personal assets of the banker, that can be car, house, document papers, or if they have any kind of fixed deposits in the bank, all these personal assets can also be taken under the control of bank. Because as we know, partners and partnership firm are one and the same. The liability of a partnership firm is unlimited. I repeat that statement. The liability of partnership firm is unlimited, whereas for a joint stock company it is limited. Yes or no? So that is why under the right of lien, bank has the right to possess or exercise the lien over the personal assets of the partners. Our second right of the banker is right to set off. The right to set off is the process of combining two or more accounts of the customer. It is a statutory right available to a banker to set off a debt owed to him from the credit balances held in other accounts of the debtor. Let me read that again. It is a right available to set off a debt owed to him. That means, let's say in a Canara Bank, okay, Mr. A has taken a loan from Canara Bank, okay, but then he already has a fixed deposit account, okay, or a savings account or an RD account, that is recurring deposit, already has an account in the same Canara Bank, okay, and he has taken a loan from the bank. Now what the statement says is the bank can set off a debt from the credit balances. In a bank passbook, whenever the money is coming in the bank, it says money is credited. Yes or no? If you're withdrawing the money, what is the message you get? Money or the account is debited. The account is debited. That means you have withdrawn the cash from the ATM. But if you're depositing the cash, what does it show? The account is credited with so and so amount. That's why it is called as credit balances. Okay, in other accounts of the debtor. So if Mr. A owes rupees 50,000 rupees to the bank, okay, he has taken a loan of 50,000 rupees, and in FD account he has a FD account amount is rupees 1 lakh. He owes the bank how much? 50,000. FD account, what is the credit balance he has? 1 lakh rupees. Okay. So when Mr. A is not paying back his loan amount, that is 50,000 rupees, along with interest, the bank has a special right. What is it called as? Right to set off. So what does the bank do in this particular situation? He is not paying the loan amount and he also has a FD account in his name. So bank is going to set off that loan account against FD account. Okay, that 50,000 rupees plus interest will be recovered from which account? From your fixed deposit account. Let's say including interest, the total loan amount comes up to 60,000 rupees. 50,000 loan plus 10,000 interest, 60,000 rupees. So from FD, the bank will deduct 60,000 rupees. What's the balance left over? 40,000. You got my point? That is called as right to set off. That is, bank can set off the debt which is owed to him from other credit balances. Now, is this right available for deposits kept in other branches? Yes. This same right to set off is available for deposits kept in other branches of same account. What are the conditions for exercising? So let's look at the conditions for exercising set off. Now, if the banker has to set off the account, that is combined loan account and FD account, what is the condition? Number one, these accounts must be in the name of the same customer. Okay, if Mr. A is owing money to the bank, that FD account or RD account must be in whose name? In the same customer's name. Number two, the amount of debt must be certain. Now, in this example which I showed you, just because he owes 50,000, okay, but he has a balance of 1 lakh rupees in FD, can the bank take off full entire 1 lakh? No. How much ever the loan amount is, that has to be certain. Principal plus interest comes up to 60,000. So how much can the bank set off? Only 60,000 rupees. Okay, nothing more than that, not 1 rupee more than that. Number three, if the customer holds the account in an official capacity, then the funds can't be used to combine with personal accounts. That's so true. Now, in case Mr. A has a joint account with his wife in the same bank, okay, in the same Canara Bank, he has an FD account in a joint partnership, okay, he and his wife together over there they have 1 lakh rupees. In this case, can the bank set off? No, the bank cannot set off. Because is his wife liable for the loan he is taken? No, wife is not liable. So the bank cannot set off such account. Or if Mr. A's business account is there, can the bank set off that way? No, because business is going to include a lot of people and the business is not liable where Mr. A has taken the loan for. Therefore, if it's in the official capacity or any other joint account, then bank cannot exercise the right to set off. Last one. If the customer is acting as a guardian to a minor's account, then the funds can't be used to set off. Isn't that right? Now, if Mr. A is acting as a guardian to a minor, now since all of you are majors, you can open the account all by yourself. But in case you're below 18 years, can you open the account individually? No. But you can open the account with a guardian. Okay, with a guardian you can open the account. Your parents would have opened account in your name long back, right? Many years back before you become a major, but your parents will be acting as a guardian to your account. So in case Mr. A has taken a loan and has not repaid and he has a lot of amount in the minor's account, can the bank set off that account? No, because a minor is involved over there. So, bank in these above conditions cannot exercise the right to set off. When can the bank automatically set off the account? Number one, on the event of death of the customer. Of course, if the customer dies, there's no other option for them to think about how to set off. But they can automatically set off the customer's account. Number two, customer becoming insolvent. That means he has no other source of income or no other ways to pay back the loan amount. That way, whatever deposit is there, whatever little savings is there in the account, the bank can automatically set it off. The last one, a receipt of the garnishee order on customer from the government. This is very important, okay? When a government, that is the court, okay, high court or supreme court, any court, issues a garnishee order to the bank, then the bank can automatically set off the account. Now, what is a garnishee order? A garnishee order is an order passed by an executing court. Okay, I just told you, right? It can be High Court, Supreme Court, any court. It is directing or ordering a garnishee not to pay money to the judgment debtor since the latter is indebted to the garnisher. I'm sure you didn't understand the statement. Let me explain to you with an example. Okay. Let's say Mr. A sold goods to Mr. B worth rupees 5,000. So A has sold goods to B. What is the price of the goods? 5,000 rupees. And did B pay for that money he has taken the goods for? No. B has failed to pay the money to A. Automatically, what does Mr. A do here? He files a case against B in the court of law. Now, what will A apply for? A will apply for a garnishee order. How can he apply for a garnishee order? Because A knows that B owns a shop. Okay, he has rented out a space, commercial space, and that commercial space is owned by a shopkeeper now, for which the shopkeeper has to pay B rupees 5,000. Let me repeat that. A sold goods to B worth rupees 5,000. B has not paid the money. So A files a case and applies for garnishee order because A knows that B owns a shop. So B every month without fail is receiving a rent. Let me repeat that. He is receiving the rent of rupees 5,000. Now what will the court do? The court will order the shopkeeper to pay A instead of B. Every month, shopkeeper is paying rupees 5,000 to whom? To the owner, that is Mr. B. Once the court issues order, shopkeeper does not have to pay 5,000 rupees to B. Whom does he pay his rent to? Directly to Mr. A. Got my point? So, shopkeeper will pay 5,000 rupees to Mr. A. That way, A has got back his money. So, who is A called as? Judgment debtor. Who is B called as? Judgment creditor. Because B owes money to A. After the issue of garnishee order, shopkeeper is the garnishee and A is the garnisher. So, garnishee means the one who has to pay money. Garnisher means the one who has to receive the money. Okay. How can you apply this example in banking terms? Same thing. You replace the shopkeeper with the bank. Okay. Now A and B are two parties and shopkeeper you can replace with the bank. The court will order the bank. Okay. Whatever fixed deposit is there in the name of B, please transfer it to Mr. A. Okay, what does the court tell? Whatever deposits are in the name of B, please transfer it to Mr. A. This is a order from whom? The High Court. Okay, that's called a garnishee order. So bank, is it concerned with A or B? It is nowhere concerned. Okay, bank is acting like a third party over here. But since the court has given order, then bank has to give the deposit of B to Mr. A. Okay. So that time the bank will become the garnishee because the bank is setting off. Okay. Automatically it will set off because the court has ordered it to. Is that clear? And A will be the garnish. That means A will receive the amount of deposit that which belongs to Mr. B. These are the three major conditions of right to set off. Hope you have understood the first two rights of the banker. Right to lien, we studied about. Legal right, particular lien, general lien, and we also studied the conditions for exercising the general lien. Next, the second right, right to set off. conditions for exercising set off, what is automatic rights to set off, and what is a garnishy order.